Gotcha. Okay, so, Mr. Weaver.
Yes, sir.
Okay, good. Hold on one second. Let me find. Okay, number 59 on my docket. I wanted to get my homework.
I think I read that earlier this morning.
Okay, Mr. Weaver, you filed a motion to terminate your supervision. You said that you've been on probation
Yes, sir.
since January of 23. You've been on, the supervision was originally, you were sentenced to 24 months, no violation. You stated that probation officer doesn't object to an early termination. Does the state have any objection to Mr. Weaver's motion?
No, sir.
Okay. Mr. Weaver, the state doesn't object, so your supervision is terminated.
Thank you very much.
Thank you, sir. So you're off probation.
Have a good day, sir.
Thank you, sir. You too. Okay, and then Mr. Rudder? Okay, but he's not present today. Okay.
Judge, will Your Honor allow Mr. Cobb to appear by Zoom?
Yes, ma'am, that's fine. Thank you. Okay, Mr. Heath.
Morning, Judge. I'm going to defer to Mr. Gates. He's going to go in my belly, if that's okay.
Hello, Mr. Gates. Morning, sir.
This is a case of State versus Tong Nguyen, Nguyen, case number 23, CF 1158. We had mentioned to the court on Monday that we'd be submitting a written plea. It's now been signed by all parties. May I approach?
Please. Let's do a misdemeanor. Yes, sir. Thank you, sir. Thank you.
And the state will be filing an amended information in this case.
Yes, sir, I've signed it.
All right, thank you, Judge.
Thank
That's
you.
all I have.
Mr. Heath, the benevolent Mr. Heath.
Good morning, Your Honor.
Good morning, sir.
I have two cases before Your Honor this morning. The first one is going to be State of Florida versus Tammy Rothacker. Your Honor, you may recall from Monday, this is going to be case number 23, CF 1029, and we're here merely to enter a plea this morning. The plea, Ms. Rothacker is to my left at the podium, and she is going to withdraw her previously entered plea of not guilty, and we have entered into a negotiated plea that has been reduced to writing. May I approach?
Yes, sir. Thank you. Ms. Rothacker, if you'll raise your right hand. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. You can put your hand down. If you'll give me 1 second, Ms. Rothacker, let me look at the agreement.
Thank you.
Good. Ms. Rothacker, did you read the plea agreement?
Yes, sir.
Do you understand it?
I do.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes,
Did you sign the plea agreement?
I did.
Ms. Rothacker, I do accept your plea. Adjudication is withheld. You're sentenced to 36 months probation, which will automatically terminate at 18 months if there's no violations of your supervision. All restitution and special conditions have been completed, and you haven't committed any new law violations. Restitution of $6,656.22, paid at a minimum of $400 per month. You'll need to pay the court cost, attend and complete anti-theft course, have no contact with the victims, and it's M-I-C-H-A-L, Bell or Amber Green, okay? When it says no contact, it means direct or indirect. Don't ask anybody to tell them anything from you. Don't post anything online directed at them, okay?
Yes, sir.
Thank you, ma'am. Good luck to you.
Thank you.
Your Honor, the other case I have is going to be the Jonathan Yates case. There's 3 of them.
Yes,
And
sir.
Your Honor, you have that set for docket day on Monday. We have a trial set. We wanted to come in here and see where we were as a status. The status is status quo. So we're going to leave it on the trial docket. Mr. State Attorney and I are going to get together, have a conversation face-to-face, see if we can't work this out. We're going to try to use the window before the trial to get it squared away.
Okay.
And that's where we are, Your Honor.
So I'll see you on Monday?
Yes, Judge.
Sounds good. Thank you, sir.
That's all I have this morning. May I be excused?
Yes, sir. Thanks,
Judge.
Mr. Heath. Ms. Chiquette?
Me?
Yes, ma'am.
Okay, thank you. Sorry, Judge.
And I should have pronounced it Jaquith like
It's
I
okay. I
usually
heard,
do.
but I was like, did I hear or did I
No.
not hear?
Well,
Because
I was reading your name and that confused me.
Your Honor, first on the docket I have is Tyra Booker, and that'll be followed by Antonio Lee, who's an inmate. Judge, Ms. Booker is present and approaching in 24 CF 177.
Hello, Ms. Booker.
Your Honor, she has reached an agreement with the state. The agreement calls for her to plead no contest as charged. She'll be adjudicated guilty and sentenced to 4 years of probation on each count. Those will run concurrently, as well as concurrent to 23 CF 1891 and 23 CF 1892. She will need to pay the $515 in court costs and the $150 cost of defense. She will need to complete a shoplifter's awareness course, maintain gainful employment, or show proof of 3 job applications per week, complete 50 hours of community service work. She'll be subjected to random urinalysis. She's to have no trespassing at any Ulta store. She'll be ordered to pay $2,062 restitution to Ulta in Destin. That address will be 34940 Emerald Coast Parkway, Unit 120, Destin, Florida. That will be joint and several with the co-defendants. And as I already stated, it'll be concurrent with her prior supervision that was imposed in the other case numbers, as well as count 2. May I
Thank you.
approach?
Yes, ma'am. Ms. Booker, if you'll raise your right hand. Your other right hand, there you go. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Yes, ma'am. You can put your hand down. Ms. Booker, did you read the plea agreement?
yes,
Do you understand it?
yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Ms. Booker, I do accept your plea. You're adjudicated guilty. You're sentenced to 4 years probation, and that's to run concurrently, run at the same time with each of the 2 counts and with each of your 2 other cases. You'll need to pay the court cost, $40 per month cost of supervision, but you only have to pay that once for the supervision you're on. $150 public assistance fee. You'll need to take the shoplifter's awareness course, obtain gainful employment, or perform 3 job searches per week, perform 50 hours of community service work, have no medications without a valid prescription. You'll need to submit to random urinalysis, have no trespassing at any Ulta store. You'll need to pay $2,062 in restitution, but that's joint and several with your co-defendants, and that's also to Ulta. Thank you, ma'am. Good luck to you.
Okay, see her and then check with her, okay? Your Honor, the next I have is Antonio Lee. Your Honor, Mr. Lee's present, 23 CF 141.
Hello, Mr. Lee.
Morning.
Good morning, sir.
Your Honor, in Mr. Lee's case, we are actually here for an order to show cause on Officer Wasson
Yes, sir.
for not appearing for depositions. Slide that way a little bit so I can have him. If I could have Officer Wasson just come up, Your Honor.
Please. Yes, sir. If you'll please come to the stand.
Yeah,
Yes,
that's
sir.
fine.
Please. Mike just kind of left you hanging, didn't he? If you'll please raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
And Your Honor, I spoke with Officer Wasson before court, so I'm just gonna kind of intentionally be vague, but summarize kind of what my understanding of what was going on. It's my understanding that Officer Wasson was involved in a car accident while on duty. He was on light duty in October when we initially served him with a subpoena. And then several officers didn't show up, so I did not ask for an order to show cause at that point because I was not sure if there had been some issue with service or something like that, and I knew we had to reset them anyway. So we reset those depositions for the end of February. At the end of February, all three of those officers that are subject of the order to show cause also did not appear. Officer Wasson was one of them. And speaking with Officer Wasson, due to issues that he's been having with results of that car accident, he's had a lot of doctor's appointments and things of that nature. I've explained to him why it's so imperative that we need him to be present for that deposition. I've explained that Officer Albrecht, who we kind of assumed was the case officer because she really took the lead, at least on body cam, was kind of passing the buck to all the other officers, saying they were the case officer. And I've also explained to Officer Wasson that if he's has a doctor's appointment out of town or something of that nature, we can always set it up via phone. I just need him to make sure he's getting in touch with me ahead of time. Based on that, if the court will release him from the order to show cause and just order him to appear for the next subpoena either by phone, Zoom, or in person, I believe that now that I've spoken to Officer Wasson and stressed to him the importance of why we need his testimony, that he will appear, and I would not have any objection to that.
Okay. Officer Lawson, do you agree to that? Okay. You're released from the order to show cause, and you're ordered to appear at the next subpoena. Thank you, sir. I hope you feel better. Thank you.
Okay. And Your Honor, as for Mr. Lee's case, we had him left on Monday for docket day for plea or continue. I'm going to ask that we waive his appearance because he's also going to be here on Thursday afternoon. I'm speaking with Mr. Gomez. Although we do hope that we can get a resolution before May 13th, it's not going to happen before Monday. But we do have on the docket already for Thursday, so I see no reason to bring him back on Monday just to sit here.
Okay. Is there any offer from the state that the state's going to withdraw before next Thursday?
I apologize, Your Honor. Thursday's hearings are the remaining order to show causes. They are not a jury trial review. I apologize for my inconsistency there.
Okay.
Also, this case set, I believe, for April 8th.
That's correct.
Okay.
So I think it would be prudent just to have it set for next Thursday.
Okay.
For a show cause.
Mr. Lee, you okay with that, not
Yes,
being
sir.
here on Monday? So we're not going to have any hearings for Mr. Lee on Monday, correct? Ms. Jacob, no
I
hearings for
apologize, Your
Mr. Lee on Monday?
There's no reason to have Mr. Lee on Monday, and Your Honor, I think it may be just
Okay,
that.
wait, but we're saying two different things. I'm talking about his case, you're talking about him physically.
Oh, I'm sorry, for Monday's purposes, Your Honor, I would move to continue the underlying case to the May 13th docket. But for Mr. Lee's benefit, he'll still be here Thursday afternoon and then again on April 8th.
Good, that's granted. I'll see you in a week.
All right. Have a
Thank you,
blessed
sir.
day.
Thank you, sir.
Judge, if I may, I have a co-defendant with Mr. Lee.
Okay.
That is Union Guzman Arredondo. She's not on today's docket, but I was tracking along with the order to show cause hearing.
Okay.
And it's a similarly situated defendant. If we could continue her off of Monday's docket to the Thursday docket where the order to show cause for Mr. Lee
Okay.
is currently scheduled, I think that would be the best way to proceed forward to keep both of the co-defendants
You need
together.
the case number?
Madam Clerk, that's 23 CF 173, and she's got a VOP, which is 21 CF 1012.
Thank you. Yes, ma'am. Who's next?
Your Honor, next is Jason Lagore. Mr. Lagore is present in 23 CF 1595. Your Honor, although we knew the charges, we were still doing some final dealings this morning. If I may just pause for a moment.
Yes, ma'am.
Your Honor, we have reached an agreement with the state. First of all, procedurally, we withdraw our motion to dismiss in exchange for this offer.
Thank you.
So now, with that being said, we have resolved with the state. Count one will be a lesser included possession of a controlled substance. That statute number, Madam Clerk, is 893.13 sub 6 sub A. As to count 2 and 3, rather, will be as charged. Counts 1 and 2 will be an adjudication of guilt, 8 months in the county jail with credit for time served, running concurrently to each other, $615 in court costs, and a $150 cost of defense. Count 3 will be an adjudication of guilt and time served. And Your Honor, we would ask that the court provide him with 180 days after release, which we kind of expect to be today, but could be within a few days. We would ask for 180 days after that release to pay those financial obligations.
Good.
Sorry.
Yes, ma'am.
May I approach?
Yes, ma'am, thank you. Mr. Legore, if you'll raise your right hand. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Legore, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Yes, she did.
Are you satisfied with her representation?
Yes, sir.
Did you sign the plea
I
agreement?
did.
Mr. Legore, I do accept your plea. You're adjudicated guilty. Lesser included offense on count 1 as charged on the other 2 counts. You're sentenced to 8 months in the Okaloosa County Jail with credit for all time served, and that's to run concurrently on counts 1 and 2. Count 3, you're sentenced to time served. You'll need to pay the court cost, $150 public assistance fee. If you fail to pay those within 180 days from your release from jail, then they'll go to a civil lien or judgment.
All right.
Thank you, sir.
Thank you.
Yep, you're good. Next, I have Stephanie Roswell, 23 CF 2686. And Your Honor, my understanding from the state is that they don't plan to demur my motion to dismiss, so I would just ask that the court grant that motion and dismiss the case.
Correct.
And finally, Your Honor, I would have John Wilkinson.
Okay.
Oh, I'm sorry, wait, I guess I
Yep,
need
hold-
to,
And-
my announcement wasn't enough. I think the court has to announce it.
It was interesting, when I did my homework, I was not aware, or hadn't seen that statute before, and so I pulled the actual statute, read through it, made highlights of it, so I appreciate that. The emergency motion to dismiss on Ms. Roswell's case, 23 CF 2686, being not contested is granted.
Thank you, Your Honor.
Thank you.
And I would just ask that the court dismiss any charges then,
Yes, ma'am.
based on that.
Correct.
And finally, Your Honor, I have John Anthony Wilkinson. Those case numbers are 20 CF 579, 21 CF 1783, and 21 CF 1785. Your Honor, he has a new law violation, 24 CF 228, that's already set for the May 13th pretrial conference. My office was just appointed last week, so I not even had a chance to meet with Mr. Wilkinson, but I need to get a global resolution, most likely for him, and at least review that new law violation to see what the facts are. So if we could enter denial for today's purposes to those VOPs and ask to have that set for the May 13th pretrial to run with that new law, and then I'll meet with Mr. Wilkinson, and I have briefly chatted with Mr. Snell. We may be able to get a global resolution. If we do, we'll get him in court early.
Okay. Has he been arraigned on that case?
I believe so, Your Honor, but we've,
Yes, sir.
I know that we filed a plea of not guilty. I
Okay.
cannot say, you know, if we filed that information on that case.
Okay. So, Mr. Wilkinson, I'll see you no later than May 13th. If you wish to enter a plea before that date, then Ms. Jakowitz can set a hearing.
Okay.
Thank you, sir.
And Your Honor, that's all I have this morning. I apologize, I had to make a note or I would forget.
No, ma'am. Yes, ma'am.
That's all I have this morning, if I may be excused.
Yes, ma'am. Thank you.
Thank you.
Mr. Garrett. I like in parentheses, also Ketchel. So you're also known as Ketchel. We have a Judge Ketchel also, just so you know.
It's a weird coincidence.
Yes, sir.
Yes, Your Honor. Your Honor, I'm here on behalf of Alexander Mayner, 21 CF 354. Your Honor, we are requesting a continuance. I don't believe the state has any objection. I represent Mr. Maynard on the new law violation in Santa Rosa County that triggered this VOP. I have filed a motion in that case that I anticipate, we'll have an argument over, or the state will perhaps offer an amended charge, something like that. Either way, we would request a continuance for
So
now.
how long do you want to continue it?
Your Honor, would it be possible to have a 2-cycle continuance?
There's no cycles in VOPs.
Oh, okay. I guess just to the next VOP date, whenever that would be.
Well, you pick when you want one. If you want it in a week, you can have it in a week. If you want it April 8th, 11th, 15th, 18th. When
Could
do
we
you think
do-
the other case is going to bubble up?
Well, it's Santa Rosa County, and things move kind of slowly there. I guess, Your Honor, I would just request a court date. You mentioned April 8th. I believe I'm already going to be here for court on that date, so.
Okay, want to do that?
Yes, please, Your Honor.
Okay, so April 8th at 9 o'clock.
Sounds good, Your Honor. I believe that's all I have.
Thanks, Mr.
Have a good
Gadd.
day, Your Honor.
You too. Ms. Dudley. Hello, Ms. Dudley. Good morning, ma'am. It appears we have an inmate on Zoom from another facility. If we can do that sooner than later, that'd probably free up that jail. So, Mr. Keach, well, no, we'll do it after Ms. Dudley's case. Do you have Mr. Hall?
They're still getting him, Your Honor, so Mr. Keach
Okay,
has to go.
yes, ma'am. Mr. Keach? Thank you. Mr. Grant, if they'll unmute, good. Thank you, sir. Mr. Keach?
Good morning, Your Honor.
Morning, sir.
As the court recalls, from Monday, Mr. Grant is set for trial. Since I was out of town, the court graciously allowed us to treat today as his docket day and allow him to appear by Zoom. We're still ready.
Okay. So trial for Mr. Grant to the state? Yes, ma'am.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Mr. Grant, I'm smiling because your attorney, they're getting ready to leave the bench, and then Mr. Keach says, and comes up with another argument for you. That the state is asking to continue your case again. This is the second time that they've sought that, but for different reasons. This reason comes down to the state intends to file a motion to consolidate. That hasn't been filed yet. I think it's premature at this point for me to grant the motion to continue. So at this point, the motion to continue is denied. If the state files a motion to consolidate and I grant that, and then that causes problems where the court has to continue it, then I'll address that then. But at this point, the motion to continue is respectfully denied. So, Mr. Grant, I'll see you on Monday, okay?
It's, Judge, actually, Monday the...
That's docket day.
We were treating today as a docket day, because I'm
Okay.
in on the 21st, I'm picking a jury with Judge Gonteric, so we are effectively using this as everything for today. So
Okay.
we just need to...
So jury review on March 21st?
I'm in trial with Gonteric on the L&L molestation with Christine
Okay.
Basso.
So then how do we prepare for trial on March 25th or April 1st?
We're
if we
ready.
don't have any hearing dates between now and
What do we need to hear if we're ready for trial?
well, it'd be nice to have jury instructions and those things.
I'll be more than happy to confer with those over email. If the state wants to send me the jury instructions, I can note any objections or reservations for that.
Okay. If the state files the motion to consolidate, then we'll have to have a hearing before to the state. Can you
on that-
plan on scheduling that for the April 1st week versus the March 25th week?
That's what we would have to do at this point, because the motion to consolidate, the deposition ran pretty late yesterday, so I didn't even get back to the office till after 5 yesterday evening. So that's why it wasn't filed after yesterday.
Okay, so I'm going to keep it on for trial on April 1st. If a motion's filed before that date, then we'll set the motion during the week of March 25th.
Yes,
And just to perfect the record, it should be noted that one of Mr. Still, the attorney for the co-defendant Riggs, filed a notice of unavailability for a 3-month period. So he's not even available to come up here to try a case until sometime after June 15th, I believe.
Mr. Still has been doing some work on the case in the meantime. I know I saw the notice of unavailability, but he has still been working on the case and trying to coordinate. He was wanting to do some depositions, so I don't know what his anticipation would be as far as trial on the 1st.
Okay. Okay, so Mr. Grant, I'll see you back here no later than April 1st, but I may see you the week before that. Okay? Yeah, that's a great point. How many do you want on the veneer?
The state chose to try to indict him on a first-degree murder with a firearm. Probably gonna need about 75.
To
I
the
just
state?
don't have any issue with that, Judge.
Okay. Thank you, Madam Clerk. Great catch.
How many days do you expect it to go?
How many days?
Probably 3.
Including jury selection or excluding?
I would think including jury selection. I've never really had a trial with Mr. Keach. I'm not sure his cross-examination, how long we would need to include for that.
Mr. Keach, you think 3's enough, or does it need to be 4?
I think out of an abundance of caution, we might want to reserve a 4th day. I don't think I'm super long-winded necessarily.
75.
But with we're certainly going to be picking a jury for a good half a day.
4 days, 75 on the veneer. Good. Thank you, sir.
Thank you.
Thank you, Mr. Grant.
Judge, that's all I have this morning, if I may be excused.
Yes, ma'am, thank you. Ms. Dudley? Status of discovery.
Judge, the standard VOP discovery with the cover sheet and the affidavit and all that information was sent to 6/24. Ms. Dudley had mentioned that she wanted the body-worn camera as well as the surveillance video from the location where this occurred. The witness's mother had advised that they told Publix, which is where this has occurred, to hold the video for law enforcement. My secretary emailed the officer to see if he could get both the body cam uploaded for us, as well as go get any sort of surveillance that they were holding. About a week later, my secretary tickled me, said she hadn't heard from the officer. I followed up February 15th, March 6th, and March 11th. And then I was advised March 12th that the e-com is available, and I asked my secretary to send that over to Ms. Dudley today. As for surveillance, the email on Monday from the officer said that there were 2 District 2 deputies who conducted follow-ups for that video, and both managers knew nothing of any sort of video surveillance hold, and video is only kept for a month. I'd also note that I called Publix this morning to try and see if they had any sound on their surveillance. It was too early this morning, the phone rang and rang, but I don't think it would have any sound on the surveillance, so I'm not quite sure how much evidentiary value the surveillance would have. I don't believe either party is disputing that they had contact, just that what was said, whether age was established between the two outside of demeanor. So I don't know how much evidentiary value the video would have, but we have made good faith attempts to secure the video. I've asked my victim advocate to reach back out to the witnesses to see if they have a name of someone at Publix that supposedly had the hold for this video to send law enforcement back out there. The body cam evidence has been sent, as well as the standard VOP discovery on 2/6/24.
Mr. Hall, you're in a jumpsuit, you're in jail, and so although a week from today is really not scheduled for violations of probation because of this, I will set you for a status conference a week from today. So hopefully the state will have more information to Ms. Dudley, and Ms. Dudley will have more information. Maybe she'll have it all by that time, or at least she'll know exactly what she's seeking and what she's asking the court to do. So I'll see you back here at 9 o'clock a week from today. Thank you, sir.
Your Honor, that's all I have. Thank you.
Thank you, ma'am. Mr. Nopes?
I've got Julian Lello. She's present, if I may approach.
Yes, sir.
Yep. What?
Thank you, sir.
Oh, no. Oh, that's just the probation. Oh, I'm happy I got this case resolved.
So, Mr. Lobello, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. So this is going to be a downward departure?
Yes, Yes, Your Honor, this is a downward departure for the purposes of a legitimate uncoerced plea bargain.
Okay.
Was the motion to exclude witness withdrawn?
I can't hear you.
Was the motion to exclude the witness withdrawn?
Yeah, we're withdrawing that based upon plea negotiation.
Okay, and this sentence is concurrent on counts 1 and 2, correct?
That is correct. That's correct, Your Honor.
Mr. Lobello, did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, Your Honor.
Did he answer all of your questions?
Yes, Your Honor.
Are you satisfied with his representation?
Yes, Your Honor.
Did you sign the plea agreement?
Yes, Your Honor.
Mr. Lobello, I do accept your plea. Adjudication is withheld. Counts 3 through 7 are dismissed. You're sentenced to 3 years probation on counts 1 and 2 to run concurrently, run at the same time. They will be early terminated at 18 months if you've successfully completed all the terms of your supervision by that time and haven't committed any new law violations. You will need to pay the court cost and a $150 public assistance fee. You'll have no contact with the victims? Who are the victims?
I'm going to read that off, Your Honor. We do not have enough space to write that in. Victim 1 is Leah Alexander. Victim 2 is James Rivera Jr. Number 3 is Nevia Massaline, and I will spell that Nevaeh. And then Massaline is Massaline. Nyla Massaline, Nyla Massaline. Millie Massaline, Millie, and then Massaline spelled the same way. And then Sean Sasser Williamson. Sean is spelled S-E-A-N, and then Sasser, S-A-S-S-E-R, and then Williamson spelled normal.
Judge, those are all listed in the information the state filed. Does the court want to look at the information so it's clear?
No, sir, but I want to make sure that Mr. Lello, even though I said I accept your plea, will rip all that up, and there won't be a plea entered if you say, I didn't know it was all those people. Do you agree that you'll have no contact with all of the people that the state just stated on the record?
Yes, Your Honor.
Okay, so you still want to enter the plea? When it says no contact, you can't have any direct or any indirect contact with them. Don't ask anybody to contact them for you. Don't post any information online directed at them, okay?
Yes, Your Honor.
Thank you, sir. Good luck to you.
Thank you.
Judge, cost of supervision, I was going to ask the court if you could waive that.
Okay. Mr. Lello, how much money do you make per month?
Right now I'm unemployed.
Okay, how long have you been unemployed?
Probably about 3 months. I have a new job right now that I'm about to start doing.
Okay. And how much money did you average making when you were working?
Probably about $1,600 a month. You know?
Okay. I do waive the cost of supervision.
Thank you.
Thank you, Mr. Noakes. Thank you, Mr. Lello.
Judge, I've got one more, and I don't know if it's on your morning docket or if it's later today, but yeah, Devin Moore.
Yes, sir.
Judge, these are simply the VOPs, and we're obviously going to deny the VOPs and ask that they run with his new case.
Okay. So when will I see Mr. Moore next? Will it be on May 13th?
May 13th.
Okay. So, Mr. Moore, I'll see you no later than May 13th on all of your cases.
Yes, sir.
Thank you, sir.
I'll be happy to see you. Thank you, Judge. I believe that's all I've got. Unless you see something else.
I'm double checking. No, sir, that's it.
Thank you,
you. Did Mr. Keach, Mr. Rare, and then after Mr. Rare, it'll be Mr. Cobb. Morning, sir.
For the record, David Rare from Miss Emily Barber, 22 CF 2541, and I'm the lawyer list judge. It's probably under Lupella for that.
Yes, sir.
Judge, we're here on a motion to compel. To date, I don't believe I've received any of the items listed in the motion to compel. Prior to our last bond hearing and before today, or after our last bond hearing before today, I did speak with Ms. Sharpless, who's the assigned prosecutor for this case. She advised she would not object to us resubmitting, as to paragraph 5, another DCF release order to see if there's something else that for some reason was lost in translation, so I'll get that filed pretty quickly. As items 1, 2, 3, and 4, again, what I'd love to have happen is a 15-day order from the court that is to be provided to us. Most of these things should be provided directly from the officers, unredacted copy of the report, information, I don't know if it's pertinent or not, that was inadvertently cut off in one of the paragraphs, page 5 of 7 of the report, the subpoena deposition tecum that was issued for Google Docs. And probably the most important piece of evidence in the case, we've still not received the anonymous child abuse hotline reported call that started the entire investigation. We just asked the state have a 15-day deadline to seek and provide those to us.
to the state?
Um,
Any objection to that request to provide the information within 15 days other than 5, which will be resubmitted?
No objection, Your Honor. I will relay that information to ASHR, please.
Okay, thank you. The motion's granted in that regard.
All right, I'll provide no objection. That's all I have. Thank you.
Thank you. Thank you, sir. Mr. Cobb?
Yes, sir, Judge.
Yes, Ryan Williamson.
Okay, Mr. Williamson is coming out. Hello, Mr. Williamson. Your attorney is on Zoom. Mr. Cobb is there. Okay. Yes, sir.
Hi, Ryan. Judge, this is State v. Ryan Williamson in 2 cases. As I had announced last week, Dr. McDonald has filed an evaluation with the clerk's office finding the defendant had incompetent to proceed to trial. I've discussed these issues with Mr. Williamson and, I think more importantly, his family. And they're ready for the process to start so that he can get some help. So I guess we just need to have a finding report and I can submit a proposed order if Ms. Davis is in agreement with the evaluation. I think it's Ms. Davis' case.
Okay. Yes, sir. Mr. Snell's raising his hand. Mr. Snell?
The state would go along with the report with Dr.
Okay.
McDonald.
Mr. Williamson? Mr. Williamson, so
Hi, Your Honor. How are you?
Hello, good. How are you?
Fine. Yourself?
Good. So all of that means, I agree, I did read through the report. The doctor found you incompetent to proceed now, but it sounds like that I'll see you in about 6 or 8 months when you're restored, when you're back to the legal standard.
I would love to announce myself as a United States citizen, Your Honor.
Yes, sir.
And if you have read your charges, or my charges, could you repeat them to me so we understood that we were talking about the same case here?
Okay, good. Mr. Williamson, you're charged with robbery, no firearm or weapon, resisting officer with violence, obstruction of police, depriving of means, protection, and then child neglect are the charges.
Well, I see no witnesses present, Your Honor, so I'm calling a filibuster on this. I've seen your appearance many times.
Okay.
So I obviously have no case here, so if you would please.
And we're not at trial yet, so there's no
just
evidence.
on the bond amount, so maybe I could go home this afternoon, okay?
Mr. Williamson, you're going to go to the state hospital, and then hopefully I'll see you in about 6 or 8 months.
Understood. I mean, I can't accept that, but if I will speak with someone more friendly.
Yes, Jason, we're going to send you down to get you.
I don't take medication, okay? I'm very friendly, okay? I was attacked by the police. You know, I would love to speak to you in person soon, okay? You told me you would be there 4 to 5 days. You never appeared to me. And I don't see any people here in the case present, so I'm calling a filibuster, all right?
Mr.
And I've
Cobb,
had 7 or 8
may I talk to
attorneys.
your client for a second?
Yes, that's
This is
fine.
my
Thank you.
original attorney. Hello, Mr. Mayner.
Can I steal a piece of this? So it's PD paper.
Thank you, Mr. Williamson. I'll see you later. Thank you, sir.
Mr. Cobb?
Yes, ma'am, that'd be fine. 6 months is good for a status. Sounds good. So Madam Clerk is setting it for, okay, and Madam Clerk setting it for September 12th just for a status. Mr. Cobb, it does concern the court when Mr. Williamson said that he thought he was going to see you in 4 or 5 days and you didn't appear.
Judge, I spoke to him via video conference last week and explained everything to him about this.
And you didn't tell him you were physically going to see him? Okay.
Difficult to go without talking about it because he doesn't understand anything that I'm saying. But I have mentioned this, John, I have talked about it.
Okay. So when you were on the video with him, you didn't tell him physically you were going to come see him?
No, I told him that the Dr. McDonald had made her ruling and that we're going to have court and that we'll talk to his family and I explained it all. He's charged.
Okay. Thanks, Mr. Cobb. Mr. Cobb, do you have any other cases? I don't think so. Thank you, sir. Okay. Any other private counsel? I don't see any. Let's see if we have any pro se's. Taylor Frazier.
That was removed, Judge.
Okay, thank
Did you
you.
say that was removed?
And then Jerome
Was it
Moore.
sent to another day by chance, or? Interesting, okay.
An order dismissing the affidavit was filed, so.
Okay, well, that's fantastic, thank you.
Hello, Mr. Moore.
Good morning.
Good morning. Case number 21 CF 1962. Does the state have an offer for Mr. Moore?
Your Honor, at this time, it's a relatively significant DOC offer, so I think it would be in the best interest of Mr. Moore to maybe see if we can get him an attorney.
Mr. Moore, do you wish for me to appoint the public defender if you qualify financially?
Yes, sir.
How much money do you make per month?
I work at Subway, I make $12 an hour.
Okay, what do you think you average making per month?
Maybe $1,200.
Okay, I do appoint the public defender to represent you. Mr. Koch?
I'm sorry, Your Honor.
Or Mr. Kleins, this is Mr. Moore?
Mr. Moore?
Yes. Jerome Moore, he's number 15, at least on my docket.
Number 50?
15.
15, okay.
Yes,
I was
sir.
like, what?
Jerome Moore?
Looks like they accuse you of violating probation. I don't know. I'll figure it out, though. Your Honor, at this time, we would enter a denial, ask that this be set on the April 8th docket.
Okay, why don't we do it April 11th?
April 11th, that's
Okay.
fine.
So, Mr. Moore, I'll see you on April 11th at 9 o'clock. Stay in touch with Mr. Kleins.
Yes, sir.
Thank you, sir. Next, we have Joan Rudd, or Rude, R-U-D. Good morning, ma'am. How do you pronounce your last name?
Rudd.
Good. And it's 23 CF 1987. Does the state have any offer for Ms. Rudd?
You just got to get to that page, Your Honor.
Number 16 on my document.
Yes, Judge, the offer of the state would be to reinstate her probation, convert it to drug offender probation, and order a substance abuse evaluation and any treatment, along with the original terms and conditions.
Okay. Ms. Rudd, have you ever been on drug offender probation before?
I don't believe so.
Okay. I can do one of two. I can appoint a public defender if you qualify financially. What's going on? Or if you want to talk to probation about what drug offender entails, drug offender probation, and then I can call you back later this morning. You can decide whether you want to accept it or not. On Ms. Rudd's case, what would be the adjudication? Mr. Snow?
So, from my memory, I don't recall whether it was a withhold at the originally.
Ms. Rudd, were you previously adjudicated guilty, or was it a withhold of adjudication?
I'm not sure, but I know that they said if I had paid off probation, I would be released. So
Okay,
that's
hold on one second. Madam Clerk's telling me it was an adjudication of guilt. So the offer from the state is you'd be adjudicated guilty of the violation of probation. You would be admitting that violation if you enter the plea. You'd be waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you. Your current supervision would be reinstated, but it would be drug offender probation. You would have to submit to a substance abuse evaluation within 30 days from today. If any treatment's recommended, begin that within 60 days from today. There'd also be a $100 cost of prosecution. So why don't you talk to probation there in the first row on the right, and I'll call you back this morning, okay?
Okay.
Thank you, ma'am. Since we've been working over an hour and a half, we'll take a 10-minute recess, and then we'll come back and finish up the morning. Thank you.